Welcome to Employee Benefit Plans and Business Sense.
Hey, everybody. Welcome back to an all new episode of Employee Benefit Plans and Business Sense with Lank and Kathleen Salas-Bass of KLB Benefits Law Group. I'm your host, Mike Leon. Dahl and Kathleen here have been helping employers and benefit plan service providers navigate the complex legal requirements of employee benefit plans. And they got decades of combined experience in employment benefits law. They bring practical real world guidance to help businesses stay compliant and avoid those costly surprises. And in today's episode, we're going to be talking about everybody's favorite, the end of year, right? The benefits and the to-dos. We're going to explain why the end of year is significant for benefit plans, what needs attention before December 31st, before you all take your 2 weeks off, and what can happen if the deadline slips by. Ladies, good to see you as always. Kathleen, let me start with you here. Why is the end of year so significant for benefit plans, and what makes this period different than other times of the year?
Well, thanks for having us, Mike. Yeah, first of all, I want to kind of clarify when we talk about the end of the year, we're really talking about the end of the plan year. And for most plans, that is the calendar year, December 31st, but not necessarily all plans. Sometimes plans have their plan year be the same as, say, their fiscal year, which, could be something like, July to June. So, the end of the year can mean different things for the plans, and it will say in the plan document what the plan year is. But for most plans, since they are on a calendar year basis, then, we are talking December 31st. And it's a special time of year because, well, for several reasons. One is that, most employers have their open enrollment period, right before the end of the year, usually October, November. And then also there are, in a lot of cases, there are amendment deadlines at the end of the year. And also there are elections and notices that might be required for the coming year, which have to be selected and distributed in the case of notices well before the end of the year. So it's sort of a time to get everything wrapped up and make sure that everything's, ready to go for the next year.
Dahl, anything on that? This is what I'm going to do for all of them. I'm just going to go like this. I'm going to say, Dahl, and you say, if you say no.
Sure. No, one additional thing that comes to my mind is since the Form 5500 has just been filed by many people who have a calendar year-end plan, they've been on extension. Many plans are on extension with an October 15th deadline for filing that informational tax return called a Form 5500 for the plan. That's due October 15th. Coming off of that October 15th filing, which hopefully got accomplished, most plans then are prepared to issue the annual benefits, the summary summary annual report, SAR, the summary annual report to their participants that describes basically, as it sums up the key data from the Form 5500 for that prior year for all of the participants to know. It's one of the transparency requirements of ERISA.
You ladies, you both touched on some of these key benefits that are going to require action. So, Kathleen, turning back to you, because you mentioned some of them, I'd love for you to kind of dive into what are the kind of filings or elections are most time sensitive that need to be made that require action before the end of the year.
Well, it does depend on the type of benefit we're talking about. Retirement plans, they have notice requirements, particularly. Some of them have notice requirements. If there's like a safe harbor plan, they have a notice that has to go out every year, about at least 30 days before the beginning of the fall, the next year. Similarly, if there's an auto-enrollment feature in the plan, they have to give a notice before the end of the year. And as Dahl mentioned, the summary annual report. Also, if there are any discretionary amendments that need to be adopted, they made a plan design change during the year and they haven't yet adopted an amendment, they have to do that before the end of the year. So, that's something to keep in mind, but also certain design changes have to be, the amendment has to be adopted before it takes effect. in which case those amendments would be needed for, in this case for 2026, they might need to adopt the discretionary amendment before the beginning of 2026. And then, every so many years, the IRS requires interim amendments be adopted for the retirement plan. And what that means is there'll be changes in law, and then the IRS gives a certain period of time, usually 1 or more years, for the plan sponsors to adopt amendments. They may have to already start operating in compliance with those changes in law, but then they give them a deadline in the future in which to adopt amendments. So, luckily this year for 2025, there aren't really any interim amendments that need to be adopted, but there will be a lot in 2026. And then for, health and welfare plans, and particularly cafeteria plans, those kinds of benefits, people have to make the elections for like what kind of health coverage they want, how much money they want to put in their health flexible spending account or dependent care flexible spending account. They have to make those elections before the start of the year in which those elections are going to, be taking place. So that has to happen. And also, unlike retirement plans, where a lot of times, as long as you adopt the amendment by the end of the year, you're good. Particularly with cafeteria plans, you need to adopt the amendment before the year in which it's going to take effect. So, any sort of design changes have to be sort of anticipated and addressed before the end of the year. As far as filings go, hopefully, as Dahl said, the 5,500 from the prior year has already been filed. There are several filings that happen after the end of the year, like at the beginning of the following year. Things like the 1094 and 1095Cs for health coverage, the W-2s that report the compensation, and then also 1099Rs if there is a distribution during the year. So those aren't year end per se. They're not due by year end, but they are due soon into the new year. So that's always a good thing to be ready for, like be gathering the data and making sure, all the record keeping is in place to issue those filings.
It's funny, Kathleen, you just mentioned something there about the forms in 26, but how early should employers start preparing for the year-end benefit task, the benefit plan task, to stay ahead of deadlines that need to be met?
Well, I mean, it partially depends on when they hold open enrollment. Most plans hold open enrollment in, like I said, October or November. Probably, for a calendar year plan, September 1st would be a good time to start looking at what needs to happen by year end and making sure that, that it's all sort of in progress. If they don't hold open enrollment till like later in November or something, they could start a little bit later, but I would definitely recommend starting, at least in September, it's around the beginning of September, just to kind of make sure that they know what they're in for.
Yeah, and I would like to add that for the retirement plans, if the plan has a committee of, an in-house committee looking at the plan regularly, which is what an in-house committee does for the retirement plan, they will be meeting with their professionals, like their registered investment advisor and a representative from their third-party administrator, and maybe even their ERISA attorney at some point in the middle of the year to prepare for these retirement plan changes that are coming down the pike as required by the IRS or the Department of Labor. There's always a lot of advance notice about when those changes are going to be effective by law. So the committee can meet in September, October in anticipation of, say it's a calendar year end plan, which most plans are.
Let's just assume the whole purpose of this discussion that we're talking about.
Yeah, so they meet, a little bit like in Q3 or the very beginning of Q4 the committee meets with their professionals to plan any changes that might be desirable that are discretionary to accommodate these changes in the law. And if there's non-discretionary changes where the law just requires a implementation of a new rule, they need to prepare for that with their payroll provider and with their, they might have to adopt a plan amendment. There's all kinds of logistical details that flow from any amendment. And certainly the required amendments, it's not discretionary. They have to make the changes. And that can affect the HR processes, payroll processes and things. And when those things are, they're run by software, all of these processes, takes some lead time to implement changes. So.
And I was going to say, because plan year end is sort of the universal deadline for all of these things, a lot of the vendors that plan sponsors work with are going to be so busy. So earlier the better, definitely.
True. Well, and it funnels into the follow-up question beautifully, which is, I'm sure as the employee, I would always ask these questions. Who's responsible for all this? So who handles, Kathleen, who handles all these tasks inside of the company?
As far as responsibility goes, I mean, ultimately it's the plan sponsor, but in logistically and in the boots on the ground kind of thing, it's usually someone, it might be, it depends on the company and how big they are and what structure they have. It could be the HR department. It could be, if they're a big enough employer that they have a benefits group within HR, it might be the benefits group. In the smaller companies, it could just be, the office manager or the owner. And then of course, some of these things are often contracted to like a third party administrator, or it could also involve benefits counsel for part of it. But of course, ultimately, it's the plan sponsor who's responsible.
Always.
So let me ask you, ladies, what are some, in your experiences, what are some common oversights that you've seen employers maybe miss when they try to wrap up their year-end benefit obligations?
Well, I would say, things like missed amendments, amendments that they didn't get signed, or also sometimes notices are sent out late. I would say the biggest sort of thing to avoid is sort of bad time management, because then that ends up making this whole thing really stressful for everybody. So, that's sort of, I would say that's the primary overarching thing, is just, don't make things stressful, because then you're more likely to make the other mistakes.
Yeah. And the best way to avoid the mess ups is to keep in touch with your provider, especially your third party administrator for your retirement plan. Perhaps in the health and welfare, Kathleen can speak better to this, but the contact might be your HR consultant or insurance contact or somebody like that. But for the retirement plan, it's very important for the employer to stay in touch with their TPA, their third party administrator, especially at this time of year, to make sure that everybody's on the same page about what's supposed to happen.
Yeah. Well, again, funnels into another follow-up beautifully, which would be, well, the deadline's been missed now. So what happens when the year-end deadline is missed? Are there correction programs that are available? Penalties automatically apply? Can you kind of explain some of that?
Oh, sure. We spend a lot of time handling corrections, not just year-end corrections, but it's. I think for retirement plans, there is a very robust correction program under IRS, and I wouldn't call it robust, but there's also some Department of Labor correction programs as well, and those are something that we work with clients all the time to fix. Sometimes it's just something that they can self-correct. Sometimes it requires a more formal sort of process. With health and welfare plans, it's more difficult because there isn't a lot of guidance on corrections. There's no formal correction program. And so a lot of times the only way to correct something in the health and welfare realm is sort of good faith corrections, doing, sort of keeping in mind that the goal is to put the plan and its participants in the same position if the mistake hadn't happened. So, so it's sort of important in that for those benefits to kind of try and figure out what is going to remedy this, whatever the consequences might be of that mistake. And of course, that's important to get counsel on that. So I would say the most important thing is if any mistake is made, anything is missed at year end, talk to your employee benefits counsel and find out what your options are. And then, if it's something like a health and welfare correction, you need some advice as to what's probably the best practice in correcting it.
Yeah. And what I would add is that time is money when it comes to corrections. So the quicker you identify corrections and contact counsel, the cheaper the correction is bound to be.
Oh, for sure. So let me ask you, ladies, because I'm sure there's been some recent regulatory IRS updates. What you mentioned, so I believe in the beginning you mentioned some of this. What are some that are recent that come to mind that employers should be aware of as they finalize these year-end benefit plan tasks?
Well, I mean, I will say that 2025 or going into 2026, there aren't a lot quantity-wise changes, but there's one big one. Probably the biggest one is for retirement plans. There is a requirement in 2026 that anyone who is eligible for catch-up contribution, and that's an extra deferral contribution that people who are 50 or older can make. If they make over a certain amount, which is $145,000 a year, that's FICA, right, Doll?
Yeah, that's FICA wages. FICA wages. Yeah.
If they make more than that, then any catch-up contributions that they make has to be on an after-tax, also called Roth basis. And so that's it was part of Secure 2.0. Then they kind of held off on making it effective for a couple of years. And they just in September issued final regulations. So everyone's kind of scrambling to be ready for this, and which involves, mainly payroll and record keepers sort of getting together with the employer to make sure the system's ready to identify these people and make sure that the contributions that need to be on an after-tax basis are made that way. Then I think one other change that takes effect next year for retirement plans is there's a requirement that at least once a year there be a paper statement to participants, which is kind of ironic because we're all trying to get less paper, more automated. But there's a requirement that in participant-directed plans, like a 401k plan, that they get a statement of their account every quarter. Plans that are not, participant-directed, they can get away with it just once a year at least. And there have been all these regulations on how you can do that in an electronic way. But now under Secure 2.0, I believe it was Secure 2.0, but it came in and once a year that has to be in paper. And I think the idea being that some people might just fall through the cracks with the electronic system. And then as far as health and welfare goes, there was that one big, beautiful bill that came out earlier this year. And the provisions of that affect benefits were mostly just health and welfare. And some of it, affects individuals, doesn't affect, employer plans. But there are a couple things that of note that an employer would want to consider at year end for next year, whether they want to do that. One is now student loan payments can be reimbursed under an educational assistance plan, and they increase the dollar limit. I think, I'm trying to think what the dollar limit is. It's going to be adjusted every year for cost of living. And so, that's something with all of the focus on student loan hardship. That's one way that an employer can help alleviate that for their employees. So, that's definitely something to consider and have in place, because they have to be ready to administer that next year and communicate it if that's something they want to do the next year. And the other change was for dependent care. The limit for dependent care flexible spending accounts has been forever, for as long as I can remember, it's been $5,000 a year, and that has now been increased to $7,500. So those are just some of the changes that take effect next year. And then then we have a bunch of interim amendments that are going to be due by year end next year.
Yeah. A lot of information out there. Ladies, we can't thank you enough for the time and insights on this. Truly appreciate it.
All right. Thank you, Mike.
Thanks.
And thank you to everybody out there for listening to this episode of Employee Benefit Plans and Business Sense. If you're reviewing right now your year-end benefit plans checklist, you want to make sure you check every box. Do me a favor, visit klblawgroup.com to connect with Don and Kathleen. Be sure to leave us a review and comment, or share this episode with someone who needs to hear it. As always, I'm Mike Leon. We'll see everybody next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.